I'm sure Director Dressler will be here in a few minutes, so I'm going to kick off the special session. The time is 5:38, calling the meeting to order. Director Biza, can you take attendance for us, please?
Lisa Hadeen.
Here.
Terry Tate.
Here.
Becky Beisel here. Stephanie Malm.
Here.
Brian Davis.
Here.
Jessica Dressley.
She is en route. All right, please stand, remove your caps for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. May I get a motion to approve the agenda, please?
So moved.
Second.
Thank you. All those in favor, say aye, please. Aye. Those opposed? Motion passes. First item for discussion is discussion of correspondence between district and legal from November 2022 and to the present. Sorry, a little tongue-tied there. So, I guess we're looking for a motion on this to start with, or do we want to have some discussion and then get to a motion? I don't care which one we do it. Let's get a motion. It's just a discussion item right now, and then we can move it on. Okay. So let's just jump it off from there. Does anyone want to provide a little context just for people that may not be aware of what it's all about? Director Tate?
Per the last regular board meeting, I had requested the legal correspondence from November 1st, 2021 to the present, because I would like this information to understand some of the legal invoices that I've been reading. A lot of them have had information regarding to school board work and other things. And I would like to have this information to make a solid decision on whether or not we renew the superintendent's contract.
All right, thank you for some context on that, and that's why we are here. Anyone else? No other conversation? You got those notes, Director Mom? Okay, just make sure we've got them memorialized. If there's no further discussion, then it's just a matter of making a motion and then determining.
I guess I was just giving a quick overview.
Yes, I was waiting for anybody else to have an opportunity to weigh in. Before we get back to that, Director Tate, does anybody else have anything else to weigh in? And if not, then I'll give Director Tate the floor again. All right, Director Tate, you have the floor.
As I had stated, there are legal invoices that are referencing open meeting law issues and, for example, for First Amendment issues, and these issues have not been brought forward to the entire board, and I think that they are worth doing so. Superintendent McDowell forwarded out an email after our last board meeting stating that it is legal's advice that I should not be privy to this information. However, because I have a lawyer and I had forwarded an email several months ago to my lawyer for a second opinion. And the fact is that Chair Davis and Superintendent McDowell were aware I had a lawyer on March 2nd per my communication to them, and who my lawyer was. And you were also aware that this firm provided a legal opinion regarding Minnesota Data Practices Act requests pertaining specifically to private emails. It had been stated from our legal counsel that all of our private emails are open to Minnesota Data Practices Acts, and it didn't quite jive with what I was reading in statute. So because this is regarding my personal emails, I thought it was appropriate to contact my personal lawyer to ask his opinion on it, which I did, and I had very clearly stated that in my email communication on April 1st to Superintendent McDowell, that I had confirmed with them the second legal opinion that I had received. So this is not new information, and so I am apparently being refused this information, at least by the superintendent and our lawyers, because I have a lawyer, which was already known. And frankly, I don't see why that is pertinent to my receiving information regarding district operations as an elected official. Any person sitting at this board table could have a lawyer and have not been truthful and transparent about that fact. But for some reason, I am being punished, I believe, for being honest about the fact that I checked with my own legal counsel about a question that I had regarding my personal emails.
Thank you. Director Mom? That's what I thought. Okay.
I'm totally fine with you having the ability to review documents. I guess what I would, just for the same reasons that you brought up, my concern is even unintentional forwarding or communication with an outside attorney or even a community member, if it is potentially client attorney privilege, even if it's unintentional, I want us to take precautions to protect the district, right? So if this is something that the board wants, I would argue that there would be one copy, either printed or digitally, available at the district office, that it would be available to all board members. And I would like, maybe if legal could weigh in, I don't know if it's appropriate or not, but that a document would be signed, that it would not, that the documents that are seen would not be copied or forwarded or communicated to an outside entity, that it would be within, you know, the people that have a need to know with the attorney's correspondence and those conversations. I even if the attorneys determined that they were not client attorney privilege, I still want to ensure that that we are doing everything we can to protect those documents so as to not degrade any future relationship with any legal firm should we have one in the future. You know, well, we will have one in the future, but regardless of what firm we go with. So that is my biggest concern, is that it would be available at the district office, that all board members would have the ability to review it, and that there may be some sort of form that we would have to sign saying that we would not in any capacity make copies of those documents. Otherwise, I am not inclined to say yes.
Anyone else? Director, ooh, that was close. Director,
You can go ahead.
okay. Yeah, Director Dressley, that's where I was going to go next.
So I was just going to say that I don't think that there's anything wrong with having us sign what would be a non-disclosure statement. But I think that we all should have access to the same information. I think it's very important as a board that we have that transparency within ourselves to all have the same access to the information.
Thank you. Director Dean.
Thank you. I think if I could see a proposal from our legal office, because I take their recommendation seriously to this point, if I could see a recommendation of how this data could be provided or made available under a context where it was we as board members could review it and it would not be shared, I would consider supporting that, but I would need to see that first, because I think respecting the board's position and respecting our role as individual board members, I would hate for us to get get sideways intentionally or unintentionally with the data release.
Anyone else with any comments? I will say that I don't really have an issue with the idea of the correspondence being available. To Director Dressley's point, I think that, it shouldn't be too difficult to say, okay, just as long as you guys are signing off on non-disclose or something along those lines. I don't think that that creates much of a problem. Having something available to all of us makes perfect sense. I agree with that. And making it a document that's available to everyone, perhaps in the district office, digitally or hard copy, is fine with me as well. So I don't have a huge problem with that. I think the only thing we'd have to do, and we could do it, I think, relatively quickly, is just make sure that, our current firm drafts something like that quickly, and we could have that done, I think, relatively fast. Director Hedin.
So this is totally a process question. So if that was to be the case, if we were to get some insight from our current legal counsel on if they felt like that there was a way to address their previously expressed concerns and make this available, I would anticipate seeing something as an item for discussion and then potentially movement to action at the 22nd of November. Is that probable or possible? Or maybe it ends up being December by the time they would have something proposed.
My thought is that we could have something, since we're sitting in special session now, we can vote and we can get ourselves set to get it made available to us within a very short period of time by doing that, as opposed to pushing it down the road, especially because part of the reason we set up the special session was because of the timeliness of it to begin with. That would just move it further away than I'm comfortable with. I'd rather try to get this resolved and act on it. Since we are in a position where we can do that, I'd like to try to get that done. And we can do a motion that will put parameters around whatever we do and then enact that. I'm gonna move back across, Director Tate.
Right, the request, the rationale for the request was to determine if we were going to extend the contract, which we have to notify Superintendent McDowell by December 1st if we plan to do that or not, or I guess maybe or not. I guess it's only if we don't. So along those lines, are we planning on having a special meeting, or at the 22nd, are we planning on having that discussion as a board to vote whether or not we are moving forward with a new contract? Or is it, because obviously we would have to have that conversation before we're able to make that decision as a board.
We could, on the 22nd, vote on that particular piece, assuming everybody had that information, assuming that the board wants to take it up, and that it's actually something where there's a preponderance of people that say, oh, we're considering this, but I'm sorry, Director Mom, you were gesturing, so I'm asking.
Can we take like a 5-minute recess? Because I don't want to
You want to look something up?
inadvertently.
Something you need to
say
research?
something.
Okay, it's something you need to research. All right, we're gonna take a quick look at something in the Privacy Act, and then we will circle back in 5 minutes, just a 5-minute recess. Back in session, sorry, time is 6:08. Apologies for that delay. That was a slightly longer conversation than I thought it was going to be. So where we left off was a conversation actually on two fronts, and Director Mom had a couple of questions she wanted clarified, so I did my level best to get those clarifications made. First and foremost, I'm going to get back to the providing of the correspondence between district and legal from November 21st to the present. There is no problem, it would appear, in providing that, as long as it's provided at the office and there are no copies or anything like that made. I was also informed that there's really no need for any signing of disclosures or anything like that, because there's an expectation and obligation of any board member that that type of thing would not take place anyway. So the signing of it, of those types of things, is not necessary because there's an expectation there. So that's first of all. Secondly, I was also informed that once said review has taken place, Director Tate and others, we can, on the 22nd, have a conversation as to whether or not a new contract would be issued. Now, if at any point in that conversation, someone wants to go into something that's performance-based or something else along those lines, despite the fact we've done a review, we have done one, then at that point, we would have to go into a closed session in order to do that. And then we'd come back out of the closed session to have a conversation again about the same. But anything along the lines would have to go in and then we'd come back out again. Is that clear? Have I made that pretty clear, everybody? Director Tate.
Just one concern. One of the reasons that I was asking about that is the timeline. So the 22nd is less than 2 weeks away. So if we're requesting that this information be pulled, reviewed, and be ready for the 22nd for a conversation, it's a tight timeline. So that's why I was asking if we would do that at the 22nd or if we would have a special meeting at a date closer to the 1st of December to allow proper time for everyone to get the opportunity to review the documents.
Well, what we'd be doing is, when you talk about the pulling of that information, that's something that would happen prior to that. I'm not talking about on the 22nd determining to do that. I'm talking about determining to do that now, and therefore being prepared for the 22nd is what I'm saying, is what we're looking at now, based on the conversations that I just had. So,
Yeah, I get that. I'm just saying if it takes a few days for, say, the district office to pull the information and then make sure that we all have enough time to review it before the 22nd. That's just my concern with the timeline. It's a bit crunched.
no, I understand that.
Okay.
And obviously, everybody will make their best efforts to get that relatively quickly and get that available to us in the offices once we elect to do just that. And then some of those components will be laid out, and we'll have that done and then get to the 22nd, and we can have that as part of our discussion with those caveats that I identified a moment ago. Director Hadeen.
Thank you. I would like to point out, as you did, that in June of 2022, a year-end evaluation was completed for the superintendent, categorizing 6 different areas: instructional leadership, finance and operations, policy and law, equity, communications, and board relations. In all of those categories, our superintendent's evaluation fell into the effective to highly effective range. I personally would not feel, while I'm comfortable under obviously we need apparently to have a controlled setting for the data release from the attorneys. I don't feel that that's relevant to a decision about a contract renewal. We have a superintendent who has very recently an effective to highly effective evaluation. So making that available is not linked to a question in my mind about the superintendent's performance.
That's duly noted. Anyone else? Director Tate.
I guess I would just like to respond that the performance evaluation, I believe, was done early June, and it is now November. So there's part of that, and frankly, it was a closed session, so I can't discuss any details, but everyone in that room was not on the same page. And yes, it ended up at a certain number, but we all have differing opinions, and we all have different ways of collecting information, evaluating information, so we are individuals, and then, you know, to come together to work as a team.
That's also fair. Thank you. I'm just looking around, see if anybody else got anything, because once we get through this, we're going to have a motion in order to get some of these balls rolling. So I'm just surveying. Okay. No further comments anybody has right now? All right. So we're going to have to make a motion. Director Tate, you're more than free to make the motion, bearing in mind what the conversation has been, and then we can get it to a vote on that, and we can move the ball forward from there.
I move to have the legal correspondence pulled between the district and the Rupp Anderson et cetera. Legal firm starting November 1st, 2021 through the present, and to be available for all board members to review in the district office with the understanding that that information goes no further than that office and that board member.
I'd second.
Any further discussion? Without any further discussion, we'll take a vote. All those in favor of the motion as presented by Director Tate, please signify by saying aye. Motion passes. And we'll get to work on that right away, okay? All right, moving to the next item. That would be MOU for teacher subbing for a colleague. We are going to vote on this again. I'm sorry. There should have been an abstention, so we're going to go through it again. Because, yeah, so here's what happens. So anybody that's connected to somebody that could be indirectly impacted by something having to do with a sub, any type of subbing situation, should stay out of it just in the event that that person ever does end up subbing for some reason. Okay. All right, so again, we've already got the, scrolling down, sorry, MOU for teachers for subbing for a colleague. We just need a motion to approve and a second.
So moved.
Second.
Is there any discussion? All right, all those in favor of the MOU for teachers subbing for a colleague, please signify by saying aye.
Aye.
Please let the record show that Chair Davis abstained from the vote. Motion passes. Those are the two pieces of business we had for our special session today. I need a motion to adjourn the special session.
So move.
Second.
All those in favor, please signify by saying aye. Those opposed, motion passes. Special session is closed.